Welcome to DrNursePaul Show, hosted by Aspire RN and Dr. Paul. You are watching the USA Nurse Series, Chasing the American Dream. Dr. Nurse Paul is an NCLEX expert, having trained and mentored thousands of international nurses past the NCLEX RN for over a decade. He graduated with a Doctor of Nursing Practice in Texas Christian University. He is a registered nurse, an advanced practice registered nurse, and a certified family nurse practitioner. He also has completed a certificate for nurse educator postgraduate course. Aside from teaching, he has extensive clinical experience in emergency and family medicine. He has over 15 years of combined clinical and academic healthcare experience. Dr. Nurse Paul is an immigrant from the Philippines. He is currently based in Houston, Texas, where he operates his business, Dr. Nurse Paul, and Aspire RN NCLEX Prep. He loves to share his life story of how he overcame his challenges to reach his dreams. He is passionate in helping nurses realize the American dream. So without further ado, let's all welcome Dr. Nurse Paul.
All right, everyone. I hope I'm clear, but I'm having technical issues with my computer right now. It looks like my computer is not streaming properly. But welcome to the Dr. Nurse Paul Show. And tonight I am privileged to have my dear friend, an attorney, a lawyer for immigration services, immigrant lawyer, popular in New York City, one of our immigrant Filipinos to the United States, Attorney Nick Caraquel. Let's bring him into the stage right now. And to give you guys an overview, Attorney Nick Caraquel is a top immigrant lawyer in the state of New York, but is also one of us Filipino who immigrated to the United States. And thank you everybody for watching the Dr. Nurse Paul Show. This is the USA Nurse Series, Chasing the American Dream. Hello, Attorney Nick.
Hello, Doc. Good evening. Can you hear me?
Yes, we can. Loud and clear.
Okay.
Thank you, sir.
So again, thank you for
I'm
having me. I
sorry.
thought I have the same technical issue as well. And again,
Mm, mm,
I will be
yeah,
happy to answer your questions. And again, thank you for asking me to join again your wonderful show.
of course, Attorney. Yeah, I was having issues too. I think it's the StreamYard, but I had to like refresh my screen 3 times, and I didn't know that I was already live because my feed was a little delayed. But anyway, thank you everyone. We're streaming this live in Aspire RN Facebook page, Dr. Nurse Paul Facebook page, and Lefora Facebook page, as well as in my YouTube. So if you guys are watching, can you please drop your names in the comment section and tell us where you're from? And if you have questions about immigration policies, about immigration questions, this is the best time to ask those questions while we have Attorney Caraquel right with us today. So this show was supposedly going to be live streamed back in November, but Attorney Nick was sick. I got sick eventually. That was the Thanksgiving weekend, probably because of the too much turkey that I ate, or I don't know. um, but thank you guys for following through. Last weekend, I talked about dissecting job contracts, but today we're going to glean a lot of important information from our attorney Nick Caraquel himself. So we're going to learn a lot of legal ambiguities that nurses are really not good of. But certainly there's a lot of questions. Like in the group Plefora, where there's 172,000 members, I'd say one of the top issues, questions are all about legalities, but we're all nurses there. So it's not like, we can probably give a little side comments here and there, but we are not the expert on situations and scenarios like this. So that's why I felt like it is important to invite someone who really knows and someone who really, understands the process. And of course, who else to talk to and ask these questions but our very own attorney Nick Caraquel. Thank you, attorney, for your time.
And again, thank you then.
Thank you, sir. Would you like to introduce yourself quickly and tell us about your immigration story?
Yeah, okay, sure. So I'm Nicholas Caraquel. Just call me Nick. People call me basically by my nickname Nick, to be short. I have a immigration law office here in New York City. I used to actually start my practice way back in New Jersey while I was still working for Nestle USA. So I think I am one of those people though who, because I don't belong in the healthcare profession. I'm originally an industrial engineer, and I think it's very difficult for engineers to come to the United States at that point. So coming to the United States is never my part of my initial dream. So I think I came to the United States by accident. I came here on a tourist visa. I was almost sent airport to airport on my first visit to the United States, and I think that's one thing of I think God had me experience that, so that when I actually advise my clients, I am in a better position to say, hey, don't be too talkative when you actually come to the United States on a tourist visa, because that might actually not help you, right? So again, my general advice to you, if you're coming to the United States on a tourist visa, just listen to the question of the consular officer. If the question is answerable by yes or no, just answer yes or no. That is not the perfect time for you to be impressing the officer with your communication skills, because that might cause you be in trouble. Okay. So again, initially I came to Seattle just to visit a friend, and then I was just lucky that I was offered a job. Unfortunately, I cannot adjust or change status in the United States, so I have to leave the United States in a week, and then I have my interview at the U.S. Embassy in Hong Kong. And then I actually obtained my L1 visa. So this is actually an intra-corporate transfer. So I used to work for Nestle Philippines, and then I was transferred to Nestle USA to work as an industrial engineer. I was a lawyer already at that time, but because I don't have a license in the United States yet, I have to work as an industrial engineer for 10 years. But 5 years before that, I already passed the New York bar. And then again, it doesn't mean that you pass the bar, you just have to leave your high paying job simply because you are an immigration lawyer already. So it took me a while. It took me 5 years to basically have that financial backing, and for me to really have that confidence to moved to New York City, where the cost of living moving from New Jersey to New York is three times the costs. So basically, you have to have that financial backing to basically help you and start your practice in New York City, where there's a lot of uncertainties, right? So I used to be having that guaranteed month-to-month income from being working as an industrial engineer, and then suddenly you have to leave that behind and take a chance of actually doing solo because no one will hire me because I am not educated in the United States. I finished my law school in Ateneo de Cagayan Xavier University, but then I was just one of the lucky people who actually just started their solo practice in the United States, and I am here now. I've been in solo practice for 5 years, and I'm just happy to share with you that we just moved to our new office here in Elmhurst, Queens, New York. So that's basically my quick story coming from the Philippines to the United States. I came in 2007 when there is a big recession at that time. So actually convincing employers how to process your visa is quite difficult, but I think I was lucky to convince them. I actually have that job offer I think within 1 month from my arrival in the United States. But then again, I have to leave the United States and obtain my L1 visa in Hong Kong, and then I was able to come back. I was able to convince my employers after 4 months of arrival in the United States to start my green card application because at that time, whenever you go out from the factory, you always see stores closing because again, that's the recession at that time. So I told my manager that, hey, you know what? I have the task of saving $6 million a year, but I'm not so sure if I have a job tomorrow. So why don't you just start my green card application so at least I can just focus on my job and not worry about my immigration status. So we started that immigration process and I become a green card holder 9 months after I arrived in the United States. And then 5 years later, I become a US citizen. So that's my quick immigration journey, Doc Paul.
Wow, what a really interesting story. You've went through a lot, and I remember the
Right.
first part. You said to not be too chatty with the immigration officers. They're not your friends. I know Filipinos are
Mhm.
very chatty, and we like to
Yes.
tell our stories. But I remember you saying whatever is asked, that's the only thing you say or answer.
Mhm.
Don't expound. No need to do that. But thank you for sharing your story. We have a couple of friends and viewers that are on today. We have Ara Bhutan from Saudi, and we have Faith watching from the Philippines. And some of them are in Lefora, so I opened it on my other computer right here because we cannot see the names. But um, we have James. I think he is in Qatar, if I'm not mistaken. He's also one of my students in Aspire R, and he's now an NCLEX passer and coming here to the United States soon. We also have Miss Anna from The Choice is Right. Thank you, Miss Anna Cruz, for joining us today. We also have Dr. Ferdinand Flores, who recently passed his psychiatric mental health nurse practitioner. Thank you, Doc, for attending. He's also from Advanced USR in Nursing. So thank you for joining us today. And please share this if you guys can do me a favor. If you can share this to your pages or to the pages that you know, to your own Facebook wall. That way we can reach out more nurses to more nurses. And if you guys have questions, I think if we have time, we will be glad to accommodate that today. But thank you for sharing your story, attorney. And my question is, what are the different pathways or visas or visa types that nurses can use to get here in the United States?
Okay, good question, Doc. No, so there are two common types of visa applications that nurses could basically use when they actually come to the United States. So H-1B, which is considered a specialty occupation, it would still be available for some specialized field of nursing. Then the most common one and the most famous one is actually the immigrant visa route. So let me elaborate on that on the H-1B because it becomes a controversial topic about 3 4 years ago when USCIS actually made or issued a guideline to say regular nursing professions are not eligible for H-1B. And of course, the Philippine Nursing Association was reacting negatively on that because we know in the Philippines, you actually have to have a bachelor's degree to be able to practice nursing. Unfortunately, in the United States, though, the regular nurses could basically work as RN when they actually have an associate degree. So
Right.
for purposes of immigration, they are actually saying that if you just work as a regular nurse, you can come in as on an H-1B. But if you are on a specialty area like an ICU nurse or a dialysis nurse, then it's actually a very strong argument that you have to have at least a bachelor's degree to be able to actually practice in that area. So the common area positions also that could actually use the H-1B position is basically a nurse manager or a traveling nurse or a practicing, again, the traveling nurse could basically go to the H-1B. But I'm always asked by most of our clients though that, hey, Nick, what is most practical approach though, whether we're gonna petition nurses on H1 or immigrant visa? So I answer that question on the practical side of the immigration process because because of the fact that nurses are very in demand in the United States. If you're gonna talk to a potential employee and you're gonna offer them H1B, chances are that they will not actually buy that offer because there are other employers who would offer them an immigrant visa, especially if the petitioner already has an approved pre-WD, because in that immigration journey for nurses, it's basically the PWD that actually takes long. As of now, it's on average taking 9 months from the time you actually submit that application online with the Department of Labor before the Department of Labor would actually issue the PWD. But if you actually are lucky enough to find an employer with approved pre-WD only, and you have that option of getting through the H-1B or the immigrant visa route, then take the immigrant visa route, right? Because again, you are just when you come in, you are already a green card holder. You don't have to worry about taking additional application to become a green card holder because the only advantage of using the H-1B route is it's faster than the immigrant visa route. So then again, we were able to convince most of our clients to say, don't offer H-1B for nurses, just give them the immigrant visa application. So again, for practical reasons, we would encourage even nurses if you have an offer from a U.S. employer giving you an H1, don't grab that because again, it's not advantageous to you. It would actually take more time for you to become a green card holder or permanent resident or become a U.S. citizen if you will go through the H1B route. The other problem going through the H1B though comes the company policies because there are company policies where they actually said if you enter the United States on H1 visa, then you have to wait at least 3 years or 4 years or 6 years because H1B has a maximum of 6 years before they would initiate your green card application. So then again, for practical reasons, if I am a nurse and there is an offer for me and I have the choice, I would rather grab the immigrant visa route as opposed to taking the H-1B route. I hope I answered that questions, Doc.
Um, Thank you for that very thorough answer. And so there was like a big debate before should we go H1B and LPR visa or
Mhm.
EB3 visa, but I guess we'll touch that later as we go further into the question. I would like to highlight this question from Ara. She said, Attorney Nick, coming to US on a tourist visa, what are the do's and don'ts when it comes to clothing? Some people I know were being randomly checked coming to the US because of the way they dressed. Wow. You have to appear a certain way coming
Right,
as a tourist. I think you should look like a tourist, right?
right. Yeah, I don't think that there is I don't think that there is a clothing code for
Yeah,
coming to the United States on a tourist visa, though. I
I,
think I would answer that question by saying that don't look suspicious, right?
yeah, true, true.
Because yeah, I just don't I didn't know or heard anything that has been blocked or sent airport to airport simply because of the reason how they dress.
Yeah, true.
So just dress normally and appropriate for the season, right? If you come to the dentist on
when
summertime, you're wearing a winter clothes, maybe you'd look suspicious at that
oh
point,
yeah, exactly.
right? But yeah, just dress casually though.
Yeah. I guess just dress comfortably and in season because you don't want to be coming in with a summer attire and it's actually winter here in the United States.
Mm,
Anyway, I think this is Anna. Yeah, I see it in. So I, for whatever reason, this is streaming live in Lefora, but we cannot see the name
right.
because it's been being um, streamed in the page, but it says Attorney Nick helped with my U.S. citizenship application stress free. So if you guys have application citizenship application coming right up, send Attorney Nick a message on Facebook. Just look for Attorney Nick Caraquel, and
Thank
we'll
you.
let the you're welcome, Doc. Attorney, we're gonna let you inform our viewers later your contact information as well. And I'm gonna flash the next question in a bit because I think that will answer my next question. So let's go to the next question that I have for you tonight, Attorney Nick. What's the difference between? I know you've touched this already, but what's the difference between a work visa, which is the H-1B that you were talking about, and a lawful permanent resident visa?
I think you actually answered by reading the question, Doc. No, so when people actually talk about a work visa, that's actually the non-immigrant visa. So
Mhm,
in your case, though, that's the H-1B.
mhm,
Basically, work visa, non-immigrant visa. But I think I will expand this question, Doc. People
mhm.
get confused between what is a work visa and a work permit. Okay.
There you go.
So
Mhm,
when you are actually being petitioned on H-1B, you can only apply, you cannot apply directly for a work permit. So people only be able to apply for a work permit in the context of an employment-based petition if your employer has already started your immigrant visa application. So I will answer this first question first. The work visa refers to the H-1B visa, and then the LPR, or the lawful permanent resident, is basically your immigrant visa. And there are two types of visas that are commonly filed on behalf of nurses. That's the EB3 and the EB2. So again, we actually talk about that in my one of my Facebook Live. The EB3 is basically coming in as registered nurses, right? Because you have a bachelor's degree. However, if you're coming into the United States either as a supervisor with a supervisory position or managerial position, and that position requires the use of your master's degree. There are two aspects of that. Then that's what we call the EB2. With that, but whether it's EB2 or EB3, they are still considered immigrant visa equals lawful permanent residence equal green card. So they are actually treated the same way.
Sounds good, Attorney. Miko has a question here. He said, "What if you are here in the U.S. not yet taking the NCLEX? As a tourist, what can be the next step?"
Very good question, though. And again, most of the time, nurses come to the United States with the intention of taking their NCLEX. And then some people get lucky that they could actually get approved of, they pass the NCLEX. And if, again, it is, be very careful, though, about your intention. If you are coming into the United States on a tourist visa with the intention of taking NCLEX, then come here to take NCLEX. So don't come here with the intention of applying for the immigrant visa. But things change while you are already here, right? So you're on tourist visa, you pass the NCLEX, and then you got an offer for an immigrant visa because they already have the prevailing wage. Can you apply for that? Definitely. You might have the difficulty, or you might be challenged by the officer at the time of the green card interview what your real intent when you first entered the United States. Again, what I actually remember what I said, do not come or intend to come to the United States with the plan of taking NCLEX and applying for the green card application, because that could be misrepresentation or fraud by reason of um, you're actually abusing the use of the tourist visa application. But then again, it's allowed for you to change status on a tourist visa. You could apply one more extension because again, you need more time to really pass NCLEX, or you need more time to actually enjoy the United States because the first 6 months was basically used to review and pass the NCLEX. And then suddenly you have an opportunity to apply as a registered nurse, then you can do that. It's just a matter of how you would answer the question at the time of your green card interview if you have one, because there are also a lot of cases where the green card application for nurses for the green card application is being waived. And if you are one of those, then you are lucky though. But for those people who will go through the green card interview and enter the United States on a tourist visa, then just be very, very careful when the officer asks you what your initial intention of coming to the United States. Telling the officer that, yeah, I came to the United States with the intention of taking the NCLEX and then apply for a green card, that might be a problematic answer. So again, the question is, what's next for me? So again, if you come into the United States and then you get lucky, you pass NCLEX and you happen to have an opportunity, then I would recommend that you consult with immigration lawyer on how you're gonna navigate through that transition from a tourist visa to a green card, because it's possible, but just make sure that you are actually guided appropriately. So again, if you need more time on a tourist visa, you can apply for an extension of another 6 months. If you have plans of going through the academy by applying for a student visa, that would actually allow you to stay in the United States longer than 6 months or 1 year, including your initial stay, then student visa is the best option for you.
That sounds perfect. That sounds like what really should be done, because I know the U.S. is very strict with the tourist visa. They want you to come to the U.S. with an intention to tour and not to find jobs or get married. I guess that's where they really don't like it and start pursuing you. But thank you for shedding light on situations like this where tourist people on tourist visas are coming to the U.S. with the real intention to get a migrant visa or something. So it's a really what's this delicate situation where you don't want to be involved in things like that, because you don't want the immigration services to find out about it. My next question is, what are the requirements for an EB3 visa, which is the most common visa that nurses are getting to come to the United States? That's the visa that I had as well.
Okay, again, EB3 is equal to the immigrant visa slash equal to the journey towards becoming a permanent resident or a green card holder, right? So what are the requirements for the EB3 visa? So I'm gonna answer this question in two aspects though. So you have the employer aspect of the immigration application, and then you have the applicant's documentation or eligibility requirements. So basically, as an employer, why do I have to include discussing the employer requirements? Because this is very important for you guys. Not everyone who offers you an EB3 route for green card are eligible employers. So make sure that when they offer you, because Doc, kasi gusto ko lang i-elaborate to kasi maraming mga nagko-consult sa amin saying yung tita ko, yung tito ko, gusto akong i-hire as private caregiver, will that be possible? Right? Because that could still be a route to EB3, right? So while there are small cases where a tito or a tita could basically convince USCIS that they really need the services of a private caregiver, but there is an additional scrutiny by USCIS if the applicant is related to them. So there are also other employers who would actually offer you a job, but there are no legitimate facilities or offices. So careful with those. So when there is somebody who offers you a job, make sure that that particular employer is a legitimate business entity. They have a business location or facility, established facilities. Because the documents that are required for the employer, though, is that they have business permits or any documentation that their business is actually a legal entity. And the most important documentation from them is to show that they have the capacity to pay. We're gonna discuss those capacity to pay in potential questions you have of what are the grounds of denying an EB3 application. But in the requirements on the employer side, that's a big requirement. They have to pass that before even initiating any step towards filing an EB3 or EB2 application. Now, once that you have established that, then you look into the requirements of the employer. Now, there are employers who doesn't require a 2-year minimum requirement or experience requirement. There are also employers who will not require a bedside experience, right? So again, it all depends on when the employer passed that prevailing wage application, they define what their minimum requirements are. So if they would actually say, I need somebody who had at least 3 years bedside experience, then any applicant should meet that requirement, else they will actually be denied because they didn't pass the eligibility requirements. So when we actually deal with a potential client, we really would want to make sure that they fully understand what they are going into, because once we file that prevailing wage application with all the requirements that they require from the applicant, then that will control the success of the EB2 or EB3 application. So as far as the requirement is concerned, is again, I'm saying if the employer would actually say, I want somebody with 3 years bedside experience, then make sure that you have supporting documentation by way of a certificate of employment, showing that you have that 3 year bedside experience. But if the employer doesn't require that, then you don't have to require that. Having foreign credential evaluation will be enough to show that you actually pass, or your degree is equivalent to the BS nursing degree in the United States. Another one is basically you pass NCLEX. There's no way the employer will be able to file your EB2, EB3 application if you don't file NCLEX. Do you have the visa screen at the time of application? No. You could basically get or obtain your visa screen at the NVC embassy stage, not necessarily at the USCIS stage. So then there are two types of processing for your I-140 application, or the petition for the immigrant worker. So most of the companies that we actually serve would want to file their I-140 application on premium processing, because filing on premium processing, the government commits itself to make that decision within 3 weeks. Normally, based on our experience, you could get an approval after a week or less than 2 weeks. And then once it's approved, it will be forwarded to the National Visa Center if the applicant is basically outside the United States. But if they don't file the premium processing because it's a little bit expensive, then normally the normal processing time is 9 months. So it will take longer, no? But regardless of whether your case is filed on premium processing or 9 months, it only means that you have to prepare getting your visa screen. If it's on premium process, then go faster though, because you might have an interview date 4 months, 5 months from the time that your I-140 application is being approved. But if the employer filed your I-140 application on normal processing, you have at least 9 months. So you can just take your time getting that visa screen. So I hope you understand fully why do you need to know, hey, is my application filed on premium processing or normal processing? Because that would actually be your indication of what's available time for you to get that visa screen. But just like any other cases, the sooner you could basically gather all those documentary requirements or eligibility requirements, like your visa screen, your NCLEX, the better for you. People actually say, hey, can I get my NBI now while we are actually processing my application? Again, the general rule, the sooner you get those documentation, the better for you. But just take note that the NBI has a validity of 1 year. So if your employer filed it on normal processing, it may be too early to obtain the NBI clearance as soon as you file the I-140 application. But I just want to emphasize, though, that people who actually work abroad for 6 months or more, when you are still in working abroad and you have planned to exit that country, make sure that you obtain the police certificate before leaving that country. It doesn't matter if your police certificate becomes expired at the time of the interview in the Philippines, let's say. For as long as you didn't go back to that country, your expired police certificate will still be enough. There are countries where it's very, very difficult to obtain a police certificate once you left that country. Qatar is one of them. Singapore is one of them. So again, there's a lot of countries that actually specify their procedure in obtaining police certificates. Saudi, where most of the applicants are coming from, once you exit Saudi Arabia or UAE, you are not required to get a police certificate. So again, what other requirements? Make sure that you have your NCLEX, that you have your eligibility, transcript of records, foreign credentials, visa screen at the time of the interview, either here in the United States or at the embassy. Basically, those are the basic requirements other than the civil documents. Now, make sure that when there are discrepancies in your civil documents, and we are talking about your birth certificate or marriage certificate, make sure that they are being corrected the earliest time possible, because it could be a potential problem at the time of your interview. But since you're talking about the doc, and we are already talking about the documentary requirements, and there
Mhm.
is this is the common questions that people come to us for consultation. when their names have suffixes, right? Just guys, you have juniors in your name, and there is a discrepancy between where these juniors are appear in their documentation, whether they are added on their first name or whether they are added in their last names. So if that's your only problem, don't worry about that. The United States have a different way of putting the junior in the names, but in the Philippines, they are normally added in your last name, correct? But regardless of where the junior is, it should not be a problem. You would be able to explain that, and this really not a big deal at the U.S. Embassy or at USCIS interviews. So I think I would answer that question that way, Doc. I will go through the other questions related to that later.
Later. All right. Sounds good. Sounds very complicated. I mean, I remember I was going through this process years back. Well, you were saying it only takes 9 months now to get processed. I took 9 years to to wait for my visa because of the recession. So I guess 9 months is a whole lot faster than 9 years.
Yeah.
So I guess for nurses that are going impatient because they haven't been receiving the response from USCIS for 2 or 3 months, you are still lucky than many of my folks years back. So we have to wait for almost a decade to get here. Some people have waited more than a decade. But anyway, let's flash some question right here. I think this is Anna, and she said EB3 visa for the win. Yes, because one advantage attorney, right, is pathway to citizenship, just like all of us here, like you, me, and many others that I've invited.
Yeah.
Yep. So and then we have hold on. Okay, let me see this. Ara asking for a friend. He's being petitioned by his mom before. However, he recently passed the NCLEX exam. Which one will help him to go to the US faster?
Okay, so first, congratulations for your passing the NCLEX exam. This is not a yes or no question, though. You have to look into when your immigrant visa application was filed. Whether it was filed while you are single or but now you are married, whether your petitioner is a green card holder or U.S. citizen. So there's a lot of factors that you need to consider before applying. But let's just assume that you just filed your family-based petition. So basically, if you are actually single, being filed by a parent, the waiting period is 8 years. If you are married and your parent is a U.S. citizen, it could be a 15-year waiting period. So based on the visa bulletin for employment-based petitions now, then the answer is yeah, go for employment-based visa applications. But then again, going back to that question, make sure that you check the visa bulletin. Make sure that you understand what visa category you are in, if you are F2B or F3 or F4, and then compare that with your opportunity for EB3 and check which date is a lot closer to current date. Then that should be your reference whether you will go for the family-based petition or the employment-based petition. But let me elaborate on that question though. Right? Kasi maraming nagtatanong na, posible ba na meron akong pending immigrant application from my family and we can also file the employment-based petition? Yes. There is no restriction upon multiple application based on different categories. Right? So, ang mangyari na lang doon, whichever comes first, yun yung i-pursue mo, then i-cancel mo na lang yung isa. No? So, again, I hope that clarifies to most of our viewers today that there is no restriction as to the employment-based and family-based petition being filed concurrently. But there is one biggest consideration that you have to make. I'm diverting the question, Doc, now, kasi
Mm-hmm.
immigrant petition family-based can also happen with spouses filing for their derivatives, right? Or using the spouse visa category. Um, the advantage of filing a spouse visa category, especially if you are already a U.S. citizen, is that you're assured that once your spouse come to enter the United States, that they will be living with you. The problem is if you are on an EB3 and your spouse, who happen to be, chances are, happen to be a nurse as well, and they file an employment base, there is a big chance that you will not be living together. So that's the consideration that you have to make as well. The
Sounds good, sir. Thank you. We're having a little technical issues in the background. I think uh somebody was trying to join the show, but they were not invited. So I don't know how that happened. But anyway, our team is working on it in the background. But anyway, we have a comment here from, I think this is Sir Irvin from Niners. And he said, thankful for this show. And thank you, Sir Irvin, for tuning in. And we have a couple more questions. We're going to go to that later. Let's proceed to our next question for the night. The next question is, what are the grounds for denial of the EB3 visas?
Okay, that's why I was holding back a while ago, right? Because we're gonna talk
Mhm.
about this. So
Right.
again, we're gonna go through two aspects. Most common denial of an EB3 or an EB2 application from the employer side is number one, if that employer doesn't really exist, right? They are actually just showing
Right.
documentation, but they are not actually legit businesses. But the most common one is ability to pay, right? And this is a problem when the employer has already filed so many applications, then USCIS are challenging them now to show their ability to pay. But also this is we also see this challenge when the employer is quite new and they will not be able to actually have sufficient documentation that they would be able to pay the proffered wage as shown on the prevailing wage. That is the common ground on the EB3 application. On the applicant side, the most common ground of the application is you are not eligible based on the prevailing wage. Just like what I explained a while ago, if the prevailing wage actually says that you have to have at least 2 years experience or you have to have at least a bedside experience, then that could be a potential problem if you don't meet that qualifications. There are instances where your application could pass through USCIS, then you appear for interview at the embassy, and then the embassy actually noticed that discrepancy, then they could still deny your application. The second ground for denial of the application is if you have a former history of denial of an application, even if it is just a tourist visa application, if you misrepresented or submitted false information or documents, that will really haunt you forever, right? There are grounds for waivers, but let's not talk about that. But that could also be a ground for denial. If you have a criminal record, as simple as a bouncing check, or theft, simple theft, that could be also a problem for you when you apply for an immigrant application at the embassy. And then the second one, if you fail the medical, I mean, the another reason is you fail the medical exam because you have contagious diseases. The good news about that, though, is there is a waiver for medical grounds, but the other grounds, criminal record, misrepresentation, fraud, if your application is based on employment, there is no ground for waiver for employment on those grounds. But if you are denied because you are a drug user, then there is a ground for that for waiver. Or if the other reason is you didn't pass the medical exam because you have you your TB tests came back positive, but again there are waivers for that and there are treatments for that. So again, those are the common grounds of denial. As of now, the only ground that could potentially be cured by applying for a waiver is the medical ground and the drug abuse.
Sounds good, attorney. That's a long list of denials, and I bet there's more. These are just the basic reasons for denial. So very intricate. So would you advise that they really need to seek the help of an immigrant lawyer? Because some of them are processing by themselves because they said they were directly hired by facilities here.
Right. I think my general advice to nurses though is if you have those information or grounds, make sure that you let your agency know before even filing the application, right? I know that there are confidentiality contracts or provisions in your contract, but feel free to raise those flags, red flags, as early as possible because if you're too afraid to actually raise those and then it will come out at the time that you are now filling out your DS-260, that's too late already. And if you don't disclose them, that's potential problem. That's another misrepresentation or fraud. There are a lot of questions that's being raised to us. Is having H1B a ground for denial? Fortunately, no, it's not a ground anymore.
Mhm.
But you have to disclose it for purposes of your employee knowing. So again, the question is, do I have to talk to an immigration lawyer for me to really make sure that, hey, I have these potential grounds. Will I have a problem? If you can afford to hire an immigration lawyer, there are actually affordable lawyers for their consultations, then go ahead, right? Because you just want to make sure that you are
Right.
actually prepared for that. Because again, if you choose not to raise those as early as possible, you cannot hide it at the embassy interview or
Right.
green card interview if you are in the United States, and it will still be a ground for denial.
Yeah, I think they do a pretty thorough background check because they know everything. They even know if you apply for a tourist visa in the past and you were not approved. So things like that you really cannot lie with the immigration officers.
Right. So in the clients that we handle, though, again, we basically cover that. And
Hmm.
again, it is our actually job to make sure that we have that pre-assessment with our
Hmm.
candidates. And then
Hmm.
once we actually see a potential red flag, we talk to the employer to say, hey, are you still wanting to file this? Because it's a potential red flag that they could still be denied because of this particular issue. And then we'll let the employer decide.
Sounds good. And let's see this question right here. One of the Facebook users. His name is Frederick. He says, I'm here in US on an H4 visa and planning to take NCLEX. If ever I pass the NCLEX, can I apply for an EB3 visa?
Yes.
Okay, so very succinct and concise answer, but actually, yes. And how about this, attorney? I'm enjoying this a lot because so much information are coming from you, Attorney Nick. I'm here now in the US, green card holder, and wanted to travel to the Philippines often, like 3 times a year for quick vacations. 1 week per visit, tops. Will it affect my US citizenship on my 5th year mark for me to apply my US citizenship? Thank you.
Uh, Generally, no. If these are just short visits, then should not affect your citizenship application. So I think I just have to elaborate more on kasi maraming misconception boss about doon sa 6 months and one
Yeah,
year.
6 months. Yeah.
Okay, so for as long as you are not outside the United States for 6 months or more on a single visit, then
Single
generally
visit.
speaking, it will not affect your citizenship application. But if you are outside the United States 6 months or more, then that interrupts your continuous physical presence requirement. If that happens to you, then when you come back, you have to, it doesn't matter if you're already 4 years in the United States and then you have that one time vacation for 6 months or more. When you come back, you start from zero again,
Oh
counting
no.
4 years and one day, right? That's the
Oh
rule.
no.
So make
Yep.
sure that you don't stay there outside the US for 6 months or more. If you stay outside the United States for 1 year or more, then you will not be able to come back because automatically your immigrant status is canceled or revoked. So
Mm.
again, as far as the multiple trips, for as long as within 5 years, your stay in the United States, physical stay in the United States is more than 50% of that 5 years, there should be no problem when you apply for citizenship.
All right, sounds good. Yeah, because I remember. I mean, I just got my citizenship this year, but I took a couple of international trips too, and they didn't ask that. They just asked where what countries you visited in the last 5 years. But anyway, the next question we have is, what should I mean? This is a big question. This is heavy loaded, but just I guess focus on the most important, attorney. What should the nurses look for in their job offers or contracts?
Okay, akala ko na-cover na natin yan the last Facebook
I
live,
know
right?
last time we talked about this, yes.
But then again, I
But
will just
still,
summarize,
this question still keeps coming up everywhere, all the
right?
time.
So again, just like what I said on the last Facebook live natin, when you actually got the job offer, try to understand the terms and conditions of that contract. Because the moment you sign that contract, because you're too eager to come to the United States, that binds you with your employer. If you're gonna challenge the provision of the contract, then don't complain. Your remedy is to either compromise or negotiate or pay those potential breaches of contract. So what should be the common areas that you would want to actually look into a contract? Number one is the working conditions, right? So, hey, where will you be assigned? What will be your basic wage? For as long as it is equal to the prevailing wage, then there should be no problem. What is your shifting pattern because that fall into the working conditions? Who pays for the fees? And again, I think it will be asked later, I would presume, right? So again, most importantly though is the nurses are very concerned about liquidated damages. And I think Attorney Trinidad from the Polo the last time actually warned us that there is really no provision of damages because it is just a result of either party breaching the contract. So it should not be looked upon as a penalty, but it's actually just liquidated damages of as a result of your action or any of the parties in the contract that entitled them to claim for damages. So again, very basic examples of what factors you need to look into: working conditions, compensation, the terms of your contract, right? For as long as you understand that, and again, it's some contracts are very complicated to understand. I would really recommend that you consult an employment lawyer or a general practitioner in the Philippines. And hey, can you interpret this contract for me? If you are actually asking me this question now, with the hope that okay, this is what I heard from Attorney Caraquel, and then I would be able to read my contract and forget about lawyers, right? That's too
Mhm.
risky too, because sometimes your
Right.
understanding of a contract may be different from a lawyer's perspective.
Right.
So my advice is for general contract review, get a consultation with a lawyer, even from a lawyer from the Philippines. They should be able to tell you what risks, liabilities, or responsibilities you will have under that contract.
Sounds good. So very important that someone reads the contract for you and making sure that it's protecting your interests as well and not too
Correct.
biased to the employer. And our next question is: does the USCIS allow petitionees to pay for their immigrant petition, or should employers pay for those fees?
Okay, very good and controversial question, right?
Controversial question,
So
yes.
for non-schedule A, so non-schedule A, any profession that are not nurses or PTs, then any activities or fees that has to be paid with your processes with the Department of Labor, 100% it should be paid by the employer. But since nurses are exempt from the labor certification process, then the first step for the employer is filing the prevailing wage. But the prevailing wage, there is no filing fee. What the employers pay is for the services of a lawyer to basically to go through that process. So that expense cannot be passed on to the potential employee. You only need a one prevailing wage. So you have one prevailing wage for a registered nurse, and then the employer could use that prevailing wage to hire 100 nurses. So that is a very minimal amount for the employer that they have to shoulder to be able to file or to petition one nurse or 100 nurses. Now, when it comes to the immigrant petition, though, and we are talking about the Form I-140 or getting assistance from the NVC or the green card interview if they happen to be in the United States, the rule actually allows the applicants to pay a portion or all of those fees. But my advice to my client though is that if the employer can basically cover those fees. Because then again, if I am a nurse and I have two offers, the other one offers me zero fee expense, then I would grab that as opposed to okay, you pay this portion. But one thing is for sure though, the employer generally don't pay for the costs of immigration for your derivative spouse or your children. Though there are employees who would cover, they are very generous employers. But as a rule, to answer the question though, yes, the rules allow for the immigrant petition that nurses should pay for that, except for the Department of Labor processes.
That sounds good. So very important to to know the difference between regular EB3 versus Schedule A. So yes, it is allowed for employees or nurses to pay for those petition fees. So,
Mhm.
but like you said, there's a lot of agencies. It's a very tight space and competitive right now in the foreign nursing recruitment because a lot of agencies are shouldering these fees. So it's really
Mhm.
all about what works for you. Choose whatever works best for you. But if there's an agency that offers it for free, I'd definitely go there. I didn't have to pay anything for my immigration fees too. Several years back, it was my agency who did it. We have a very good questions. question here. If there was a question from one of the Facebook user that says if she has dependents that have B1, B2 visa, will they be revoked once the EB3 process starts?
Okay. If my dependents have B1, B2 visa, will that be revoked once the process starts? Not necessarily, though. The B2 visa will only be revoked once the immigrant visa is approved.
Right. And this is a long question. I'm married but not legally separated. I have two kids with a partner. My youngest named after him. However, the eldest was not, but both of them were his. I wanted to bring them along with me when I go to the US. What should I do?
Okay, I'm married but not legally separated. I have two kids with a partner. My youngest named after him. However, the eldest was not, but both of them were his kids. So, pakitulungan ako i-understand yan ha. My youngest named
I'm
after him. However, the
I'm
eldest was not.
I'm thinking she's married to another person and she now has a partner with two kids. So one kid probably has
Both of them were
the
his. So I think ang understanding ko dito, and again, correct whoever raised this question, can you just give
yes.
a clarificatory question because
Yes,
medyo
please.
hindi masyadong klaro yung facts, right? So
Yeah,
my
yeah.
youngest named after him. However, the eldest was not, but both of them were his.
So I guess it's talking
So
about the person that she was married to.
okay,
That
Doc,
the
can we
kids
go
have
back to
different
this
last
question? If I will just
Yes,
ask the whoever
actually,
asked
yeah.
it to clarify
It,
those facts. Okay.
it's not very clear, but let's see this question. Will be previously married be a problem, especially not yet divorced? So I think they're thinking of moving to the US and leaving the spouse behind, and they're not divorced, but there's no divorce in the Philippines or something.
So will previously married be a problem, especially if you are not divorced? So let's take that perspective that you have, Doc. No? So example, iniwan mo yung asawa mo, then you would want to come to the United States. Will it be a problem? No. You could basically leave behind your spouse because you don't want to bring them here. But if the context of the application, the question is, I am previously married, but I'm not divorced. And then if you have plans of petitioning other spouse, then it will be a problem, right? But
Yep,
if the only context is I don't want to bring my spouse, uh, I'm not divorced, then it's okay. You can
I
leave
think
behind
that's
your
it.
spouse.
I think now that we're talking about this, I feel like the previous question talks about, okay, I'm married, but we're not together anymore, and I have a new partner, and I have kids with the previous partner. So I guess she's thinking, can I bring my kids? Can I bring my new partner? Well, this really needs an immigrant lawyer, huh?
Sige, yeah. So
Sounds
again,
complicated.
dalawang option yun, Doc. Doc, i-clarify niyo yun or consult with a lawyer.
Right.
Right?
It's a little complicated, right? Anyway, let's go to the next question that we have here on our list is, what can immigration lawyers like yourself help our nurses with in their petition process? So I guess we've already mentioned it earlier, but yeah,
Right. Again, most employment-based applications have been represented by lawyers, right? This is in
right.
recognition that hey, the immigration process is complicated. It has a lot of left and right turns. That's why most employers would avail the services of a law firm to be able to guide them because that's their expertise. The second question is how could a lawyer help the applicants? I think that's the context of the question, Doc. Correct?
Yeah,
Ngayon, kung ang situation nyo is very clean, right? You have these 2 years, if that's the requirement of 2 years relevant experience, you have that NCLEX certificate, and you have this all documentation that's required. You don't even have to consult a lawyer because that's part of the whole analysis assessment of the law firm does. But just like na sinabi natin kanina, meron kang konting tinatago, right? Then it might be the time that you would consult in a personal note an immigration lawyer to help you navigate ito yung issue ko, anong pwede kong gawin, right? There are also issues where I don't want to bring my family with me for the first time because I need to adjust to the United States and I don't want to bring them with me. Then that questions normally are not being answered by your employment lawyer, or by your agency, then in that case, you might want to have a consultation with an immigration lawyer to help you understand what would be the consequences or problems, if any, if you're gonna leave your derivatives behind. So, but again, just to summarize my answer, as far as you don't have again issues, you don't need to consult with immigration lawyer as far as your employment-based application is concerned. But if you have those issues that's bothering you, then consult a lawyer to help you understand what will be the potential risks and problems that you might have going through the process.
Right. So only for those certain very distinct scenarios where it will be hard to judge for the immigration services if they will be approved or not. So anyway, one last follow-up question, I guess, before we wrap this up. How about previously married in the US, but in Philippines, I'm single in papers or records and have different family now.
It's not
I guess she's the same person who said, can she bring her family here or something?
okay. How about previously married in the US, but in the Philippines, I'm single in papers or records
Or
and have
records.
different family now? How about previously married in the US, but in the Philippines, I'm single in papers or records and have different family now? I think if the question is you are single in the Philippines, if so, if you're previously married, as long as you are divorced in the United States,
Yeah,
then there
should
will
be
be
good.
no problem petitioning somebody in the Philippines because there is no record of your marital status
Marriage.
in the Philippines. The
Right.
potential problem is if you are previously married in the Philippines, you got divorced here, but not annulled in the Philippines, and you petition somebody in the Philippines, then that will be a potential problem.
I guess that's the answer to the question. Thank you, attorney. Any last word, advice, messages to our nurses that are interested of coming over to the United States?
Yeah, okay. Again, more than 1 hour na pala tayo, Doc, no?
Yes,
So I think we only have 10
always. It's
questions, right?
yep, yep.
Right. But again, thank you. Again, thank you for having me, Doc. It's always a pleasure for me to be able to share my
Thank you,
knowledge
attorney.
to the Filipino community, right? Because that's one of my advocacies.
Mm-hmm,
Again, thank you for welcoming me to Lefora to be able to answer your questions. And
mm-hmm.
again, I thank Jean Oliver. She's my classmate in when we were in high school.
Hello, Ma'am Jean.
Right. And again, thank you for inviting me to join the fora. And the main reason why she invited me in the first place is for me to be able to answer some legal questions in the group. So then again, thank you for having me. My advice and my last message to our viewers who are basically nurses, strong community of nurses. If there's something that bothers you, that affects your immigration status, don't attempt to do it yourself. You
Right,
might actually be digging further on your problem, right? I know
right.
that there are a lot of information available on in the internet, but when you go through that, there's also a lot of conflicting information. So I think
Correct.
the best way for you is to have that consultation, though, right? It might be not all lawyers are pricey lawyers, right? So if you could
Right.
find somebody who are actually charging you reasonable fees, then invest on that, right? Don't ask advice from your neighbors and from your friends because you might be in trouble. I've actually seen a lot of situations where they are ill advised. The
Right.
friend and the neighbor has good intentions, no problem with that. But because they are not experts on the field, the advice that they might be giving you is not the appropriate advice. So I think that's
Correct.
the only advice I could give everybody. And again, good luck on your immigration journey. And I hope that everybody will be attaining their American dream in due time.
Thank you, attorney. How last thing, how will they contact you if they want to contact you? Because somebody asked on the comments, how did they contact you? How did they get a hold of you?
Okay, thank you very much, that doc. So again, we have our landline basically in the United States is 1-917-832-7414. But I think the best way is to visit our website www.idreamamerica.com. If you would want to send me a message, I would recommend that you message I Dream America too, because there's a lot of staff assigned to answer queries there. If you're gonna send me a message personally, it will go to my spam folder, which I may not be able to read. So I would recommend either you would go to our website and send via email or send a message through the America I Dream America 2 Facebook account. And again, thank you very much
Thank you,
for
Attorney
having.
Nick, for your time. I know I bothered you a lot for this show, but I'm pretty sure, I'm 100% sure there's gonna be follow-up questions. So we might need to bring you in here soon. But I mean, it's almost holiday, so let's have a rest for the rest of the year. Merry Christmas, Attorney Nick, and thank you so
Give
much
my
for your
to
time.
your doc and to the whole nursing community in Lifor. Bye bye.
Thank Thank you. Bye. And
Thank
for the
you.
Dr. Nurse Paul show, we're going to have more shows this Saturday. We're going to have the Secrets of the Next Generation NCLEX episode 5. So the Secrets of Next Generation NCLEX will come back this Saturday, 8 a.m. Central Time, um, here in the US. It will be about sample case studies again, question, another case study scenario, and we're going to have to answer that, teach you some techniques. So please join me in this show. There will be one winner of a 1 year unlimited NCLEX review package from Aspire RN. So please share this show to your friends. This will be on Saturday, 8 a.m. Central Standard Time in the United States. And for everyone's information, before I end this show, Aspire RN NCLEX is running a 50% off on all their programs on their SurePass Pro program. I'm sorry, 50% off on their SurePass Pro NCLEX 1 year unlimited program. This is only until Christmas Day. So if you guys are interested with this, kindly message me in my social media, Dr. Nurse Paul, or you can also message Aspire RN directly, and our team should be able to help you. And there's a lot of nurses that have already joined, and you still have a chance to join 50% off for all for the NCLEX Unlimited program. And message us and we can help you. Okay. And one more thing, if you are a recent Philippine nurse licensure exam passer and you have over 85% score in the local board examination, I have a scholarship offer for you. So send me a message right now at Dr. Nurse Paul, and you're going to get your NCLEX review program covered under Dr. Nurse Paul and our participating agencies. So send me a message now. You're going to get your NCLEX free if your score in the Philippine nurse licensure exam is 85% and above. And again, thank you, everybody. Please tag your friends in this show. This is recorded. You're still gonna be able to watch it later. And see you on the next Dr. Nurse Paul show. Bye.
You have just watched the Dr. Nurse Paul Show. Watch us live every Saturday, 8 a.m. Central U.S. Time. For more info about our future events, follow us on our social media channels. You can find us at Dr. Nurse Paul on Facebook, Instagram, TikTok, and YouTube. See you next week.